Welcome, everyone. I would like to introduce Tamara to
Hi, happy Sunday, everyone. We have here founder and owner himself, Mr. Andrew Dennis, who's gonna take us to the passing path of the bar.
the promised land. I love that. All right, so I was just showing in the class, we have a bunch of digital materials, MBE, Florida Bar Q&A, LSAT Q&A, which is really fantastic, and SAT if you have any young children at home, or I guess not that young, but students at home that want to take the SAT. We have lots of materials. I'd love to showcase them for you, but today we're just going to do a few questions from our Q Bank. Let's start with real property quiz number 1, and I'm just going to walk you through these questions because I think that'll be helpful, and then we'll let Vanna White, Miss Icky Vicky herself, showcase some interactive questions. Okay, so if I saw this question, how would I approach it? First thing I would do is go to the call of the question. When the buyer refused to close, the mother sued the buyer for specific performance and properly joined the son as a party. Who's likely to prevail? The mother, the buyer, or the buyer? So I'm reading this with the thought of who's going to prevail in this situation, the mother or the buyer? That's the first question I'd like to figure out. Well, what's going on? A son executed an instrument in the proper form of a special warranty deed purporting to convey a tract of vacant land behind his restaurant to his mother. So I'm already thinking about some terms. Son purported special warranty deed, meaning what the son conveyed in the deed was only warranties of title for the time that the son had the property, nothing before downstream chain of title, right? And the reason I do this, even if it doesn't end up being relevant, it's kind of like you want to orient yourself. So son conveys a special warranty deed. I know what that means. And he conveyed it to his mother. Nice, good son. The granting clause of the instrument ran to the mother and her successors forever, so long as the land is used for business purposes only. So long as the land is used for business purposes only. So long, what does that sound like? Durational language, right? Durational language would make it what type of fee simple, or what type of fee?
Determinable.
Possibility of a reverter.
Yeah, fee simple, determinable with the possibility of reverter, right? So it's a defeasible fee, determinable, possibility of reverter, because it's durational language, so long as it's used for business purposes only. Does anyone know what's one effect of durational language on a conveyance? What if that person tries to reconvey it? Does anyone know? Any thoughts there? Like, I already have a thought, but I'd do this. Does anyone else have a thought about what that would mean if you tried to convey land that had durational language that made it a fee simple determinable? Would that be okay? Can you convey it to someone else, or what might be a problem there?
I mean, the one potential problem would be like if the person they're trying to convey it to does the activity that they're not allowed to do.
So, okay, true. But even before then, we'll get there. Okay, I'm not even gonna.
You can only
Is
say
it-
the property that you actually have, and if there's a condition, you don't have. There's a condition, you don't have the property yet, so you can't convey what you don't have.
Kind of, yes, you're getting to it.
You're removing someone's interest?
So what aren't you conveying? We're about to get to. Good.
Title.
What? Wait, you said title? I like that. Someone else. Unmarketable. Yes, Yasmin said. Yeah, Yasmin, exactly. It's not a marketable title, right? Like, okay, you didn't need to jump to that conclusion. I'm pretty trained to jump to that conclusion. I'm not just jumping to conclusions, but I'm just saying when I see words, I try to associate. So special warranty deed only protecting chain of title, or not chain of title, only protecting title while they had it. Okay, now there's this durational language. That's going to constitute a fee simple determinable, which would have an automatic reversion if this condition occurred. Knowing that, it makes me think of, oh, well, that would make it unmarketable. You can't convey land with that condition. It would be like having an easement, having a mortgage, having some weird zoning ordinance, having threat of litigation on the property, right? Something that would make it unmarketable title, right? So it potentially could be unmarketable. I don't know if it's gonna be, but it potentially could be. The mother took possession of the vacant land behind the restaurant and used it to set up a booth selling handmade jewelry. Okay, mama, do your thing, sell that jewelry. After a few months, the mother decided to stop making jewelry, okay, that's the business purposes, and entered into a vow and written contract to sell the land to a buyer for a reasonable price. So now she's trying to sell it, but she doesn't really have marketable title, in my opinion. You could still potentially sell it, but the buyer would be taking a huge risk, as Gabby was saying, right? Like, you got to use it for business purposes only. However, the buyer wanted to use the land to build a small efficiency. Of course, this is a vocab test, and efficiency seems to implicate like residential use. The contract did not have any provision relating to the type of title the mother was bound to convey. Huge sentence right there. There was no type of title, but what is still necessary?
Marketable title.
Yeah, marketable title. Even if it doesn't expressly say that there must be marketable title, there must be marketable title. It's called the implied warranty of marketable title. We agree? When the buyer refused to close, the mother sued the buyer for specific performance and properly joined the son as a party. Son's a party. Okay, son, good for you. Who do y'all think should prevail here? Based on like how I kind of already went through it.
The buyer.
The buyer, yeah, and why? Okay.
D.
I haven't even showed the answers yet.
Because he is a BFP.
The buyer, you're saying, is a BFP, that's why he should prevail?
Correct.
The son's
don't-
interest is the one that prevents it, right?
Yeah, the son's interest prevents it. So how would we really like, without, I don't know how you guys are already talking about the answer choices, but pretend you're not. Without even looking at the answer choices, how would we articulate this argument? The buyer should prevail because the seller failed to provide
Marketable title and
marketable
therefore
title. That's
the-
what I would say. Like,
Yeah.
to me, I don't know what the answer choices are. And the better you can get at just kind of like understanding the argument and being a little bit predictive, you know, maybe that'll help us. I don't know what the answer choices are going to say, but like, to me, does anyone disagree with that? Like, there wasn't marketable title here because this condition on the land made it unmarketable. And this right here is not going to protect them because it's an implied warranty. We agree? Okay. Who's likely to prevail? The mother, because the granting clause includes a valid restrictive covenant. The mother, because she has fee simple absolute. She definitely doesn't have that. It's not B. She didn't have fee simple absolute. She had fee simple subject. No, not fee. She had fee simple determinable. There was a reversion. The buyer, because the contract did not have any provision relating to the type of title the mother was bound to convey. Again, we don't like that answer because it doesn't need to be expressed. It's an implied warranty. D, as Diana was predicting, the buyer, because the son's interest prevents the land's title from being marketable. That really gets to what I was predicting, right? There's no marketable title, right? The mother holds title to land by a special warranty deed that conveyed a fee simple determinable. However, the possibility of reverter held in the son makes this title unmarketable. Smooth explanation, right? Any questions about that one? All right, I'm gonna do a couple of these and then we'll do them as a team, you know, on a different platform. My friends texting me about the Eagles. All my friends at home are betting on the Eagles. So if they win tonight by a certain amount of points, it's gonna be a major party of a bunch of my friends back home. If they lose, still be a good day. All right, let's talk about Kai. So holy bananas. The investor sued Kai for breach of contract, claiming damages from Kai's failure to convey marketable title, which resulted in investors' loss to the sale of Andrew. So here we have another failure to convey marketable title. Okay, so who's like Reveal, Kai, the investor, Kai. People ask me, Andrew, do you really read the answer choices before you do the question? Not really, but I kind of want to see like, what am I trying to figure out here? Is it going to be Kai or the investor? I didn't read why. I just want to know like, okay, generally, what am I being called to do here? I'm trying to be called to find who's going to prevail, Kai or the investor. Fair enough? Okay. So Kai downloaded a real estate contract from the internet because Kai wanted to sell a part of land. Kai met with an investor at a coffee shop. Thereafter, Kai entered into a written contract to sell a part of the land to an investor. Okay, Kai, do your thing. Sell the property to the investor. Kai and the investor later completed the sale, and Kai delivered a general warranty deed to the investor. All right, so the property involved is the investors now, right? Kai delivered a general warranty deed. 6 covenants of a general warranty deed: covenant of season, spell with the S or a Z, depending on how you like to spell it. Right to convey and right against encumbrances. And then the future warranties of general warranties, further assurances, and quiet enjoyment. Again, I don't know if that's what the question is asking about, but like, it's good to have trigger when you see general warranty deed. Again, you have to do this quickly. You can't not answer all the questions on the test. That's like, I really don't want that to happen to people. If you don't answer all the questions on test day and then you call me and say, hey, Andrew, I didn't answer all the questions. How do you think I did? I don't know. I can't be confident in a student who didn't answer all the questions. It's not fair, like you gotta try to answer all the questions. So like do it quickly, but quickly I'm like, all right, general warranty deed, there's 6 covenants. All right, bet. Okay. The contract did not mention any clause relating to the quality of title. Again, second time we've seen this sentence. What's the effect of that sentence? Anything?
Distract you away from the fact that
Yeah, no effect, right? If you guys are seeing it, do you guys see it says create flashcards with paper clips? You guys see that? That's some, I've been using an AI, not AI, but like that's an AI thing that you can like copy from a website and then it'll create flashcards for you with this app called Paper Clips. It's like an AI app. I don't really use it, but you guys can try it out if anyone knows about it. All right. A few days later, the value of the land increased dramatically. So the investor thought it would be a great idea to make profit from selling the land. The investor entered into a written contract to sell the land to Andrea. Okay, so now we have the value of the land increased dramatically. So the investor thought it'd be a great idea to make a profit from the land. Smooth investor. He picked the property off of Kai and then flipped it to Andrea, right? Smooth. He entered into a written contract to sell to Andrea. Now the contract between the investor and Andrea expressly provided that the investor would convey marketable title. Again, that sentence doesn't really matter. If they expressly or didn't do it, marketable title is always implied. Andrew retained an attorney for the closing. There you go, Andrea. That's my tocayo. Does anyone know what that word means, tocayo? Okay, don't be distracted. Her attorney found that the title to the land was not marketable and had not been marketable when Kai had conveyed the land to the investor. All right, so Kai was a sneaky little Kai over here. He didn't have marketable title when he conveyed it the first time, and then investor flipped it. Now the investor sued Kai for huge set of terms. It all came down to that breach of contract. Does anyone else agree with me that the entire question just came down to this right here? Why, Tamara?
Because once the contract is completed, you cannot sue on contract because it turns into a title.
Exactly. It's what's that called? The concept of what?
Merger doctrine.
Yeah, there you go, Heather, with your little vest. I see you.
It's 15 degrees here in Nashville.
What are you on oh, that's where you live in Nashville?
No, I'm visiting and I'm being a good student and doing class.
You're in a bachelorette party?
No, I'm celebrating my birthday.
Oh yeah, your 20th birthday. I know we have another student who has a birthday today, but I don't think she's here. It's her 26th birthday. Yeah, Stephanie. I saw on her social media, she had a whole photo shoot done for her 26th birthday. Which is cool.
Merger doctrine.
Merger doctrine. So the investor sued Kai for breach of contract, claiming damages from Kai's failure to convey marketable title resulted in investor's loss of sale. Okay, so I think it all came down to this right here, that breach of contract. You can't sue for breach of contract after there's already been literally a general warranty deed that was delivered. And then there was a whole nother, like, it's way too late to sue on the contract. Does anyone agree with me, disagree with me? I agree, it's a merger question, I hope. So all because of this, if the investor would have sued Kai for a title, defect of title, then maybe there would be an argument here, but here's breach of contract. You're going to lose, investor, I think. So who is likely to prevail? And if it's Kai or investor, I'm going with a Kai answer. Kai, because the obligations as the title merge into the deed. I mean, that's like pretty much the answer. The investor, because the real estate contract was not created by an attorney and downloaded from the internet. It doesn't need to be. Anyone can create the contract. Go to rocketlawyer.com. I shouldn't have given them a shout out. The investor, you gotta pay me for that, Rocket Lawyer. The investor, because in every real estate contract, there's an implied covenant for title to be marketable. That is true, but you're not suing under the title here. It literally said for breach of contract. So no, B or C. Kai, because the investor assumed the risk of not running a title search on the property. I mean, maybe not. A is the best answer here because you can't sue in the contract. We agree with A? A is correct. The investor's remedy was based on the deed. he received and not on the contract of sale because the contract merges into the deed after the closing. All right, I like that. We'll just do maybe one or two more. Ooh, spooky town. Okay, so will Chucky prevail? Yeah, I don't know. Yes or no? We're just gonna see if Chucky's gonna prevail. That's the issue here. Okay, so Chucky owned land located in Spooky Town after he took out a mortgage on the Elm Street Bank that was secured by a mortgage on the land. Okay, so Chucky owned land in Spooky Town after he took out a loan from Elm Street Bank that was secured by a mortgage on the land. So, okay. The promissory note expressly stated that Chucky had personal liability on the loan. Okay, that makes it simpler. From this statement, we know that Chucky is personally liable on a loan. They literally told us Chucky is personally liable on a loan.
He
One-
assumed the,
Go ahead. Oh, sorry.
he assumed the mortgage.
Yeah, I mean, he's it has the same effect of him expressly assuming it, right? He personal liability. 1 year later, Chucky sold the land to Michael Myers, who expressly assumed the remaining debt on the property. So now Michael Myers expressly assumed it, and Chucky, will remain liable as a surety, right? Does that make sense to everyone? It's actually not an easy concept. Sometimes you get so deep in it in bar prep that you like turn really complex concepts. Like, duh, I know that, but like that's not an easy concept. If anyone has any questions, feel free to ask. But right now, Chucky is secondarily liable as a surety on the mortgage, and Michael is personally liable, primarily liable on the mortgage. Does everyone understand that? I know someone's not paying attention, but I'm trying to be nicer. Okay, after 6 months of successful mortgage payments, Michael Myers failed to make 2 payments. To prevent foreclosure, Chucky paid the overdue mortgage payment directly to Elm Street. Okay, so 6 months of successful mortgage payments, Michael Myers failed to make them. Michael Myers is personally liable, right? Chucky paid them. To prevent foreclosure, Chucky paid the overdue mortgage payments directly to Elm Street. So here you have a situation where the personally liable party did not make payments. The secondarily liable party, the surety, made the payments, right? So what's the law there?
If I can say, the law is that when two parties are liable and the secondary this person who secondarily assumed their mortgage refuses or does not pay, the surety, which is the first mortgager, is liable. It can sue the second person and can recover from unpaid mortgage fees.
Almost, I mean, pretty much. I just think we said the terms a little bit off, but the first party who's primarily liable is the one who doesn't make the payments. The second party who's secondary liable, the surety, makes the payments. And in that situation, the surety, the one who's secondarily liable, can recover from the first party, the personally liable, primarily liable party. That's the rule of suretyship, that if the secondary liable party pays, and here the secondary liable party is going to be Chucky because Michael Myers expressly assumed it. So Michael Myers is the first primarily personally liable party. Chucky is secondarily liable as a surety. Chucky made the payments. Chucky, as secondarily liable, will be able to collect from Michael Myers. That's the rules of suretyship. After making the payments, Chucky is doing exactly what he's entitled to do, which is sued Michael Myers for the money he paid for the bank to avoid foreclosure. So here, in this circumstance, who will Chucky be likely to prevail? The answer is yes, right? Chucky will be able to prevail because he made the payments and he was a surety. They weren't his primary responsibility. So no, because Chucky had to initiate a foreclosure action before taking on the responsibility of payment. No. No, because Chucky took out the loan and was secured by the mortgage on the land. No. Yes, because Chucky is permitted to seek reimbursement from Michael Myers. That's probably the answer. Yes, because Michael Myers purchased the land, removed Chucky's liability on the loan. The answer is going to be C, right? He's permitted to seek reimbursement from Michael Myers. So the right to seek reimbursement under the law of suretyship requires that Chucky be personally liable on the loan, which he was because there was no novation or release. Okay, so those were a few questions that we did off our question bank to, demonstrate that there's a lot of resources out there, and we tried to write new questions that you haven't seen before. So if you're someone who complains, oh, I've done all these questions over and over, you can do our entire Q bank. And I just changed the settings. So now it'll tell you, like, when you finish a chapter, you'll get like a certificate, and like, you can really try to finish the entire question bank, and that should really lead to success on test day. But we're not going to reinvent the wheel here. I'm going to do what I've been doing for a few years now and use one of the commercial Q banks and make it more randomized, because some of y'all have actually done those quizzes already in order. So I don't want to, make it too easy. But Vicky, are you paying attention? I didn't think you were paying so much attention for those last 3 questions, to be honest, judging by.
It's okay.
Did you learn anything from those 3 questions, or was it total like you were listening to Bad Bunny in your head type experience?
I was just really getting prepared so that I could do a
So you
great
could
job
focus.
with these.
I could tell.
Yeah.
I almost asked you something, and then I was like, I can't, because you weren't paying attention. And it's just, it's an old professor trick, is like you notice when someone's not paying attention, and you ask them a question, and then the rest of the class pays attention so that it doesn't happen to them. You know what I mean? But I didn't even want to do that. I'm in a good mood today. I need the Eagles to win. All right, can we share screen? I can. Can you share your
Yes.
screen?
Hey, Andrew, before we move on, can I ask a question real quick?
Sure.
So it definitely helps that you break down the question, because then I'm able to catch what the issue is, and the words, like, what the first one about the marketable title, that, it merges. Obviously, I know that, but I would have missed it if you hadn't pointed it out. So how in 1.8 seconds can you look at the question, for test day? How can you look at the question and spot like those particular,
I mean,
do you know what I'm saying? Do you know what I'm asking?
I know what you're saying, and honestly, the answer to that is extremely complex, right? Like, it really is. How can someone neurologically arrive at a association at such a quick speed is actually a really difficult question to answer. I'm just giving you the truthful statement. Like, some people it's processing speed, some people it's, total amount of processing space, right? Like, those are 2 different, if you consider the brain like a hard drive, and that's probably unfortunately a fair way to consider it, like, there's 2 different considerations there. How much space do you have? How many, bits are you allowed to have in your brain? And then the other one is, what's your processing speed? And like, now we have quantum mechanics. So right now, they could literally much explain the universe in a millisecond. I'm not going to explain quantum physics to you right now, but in a really, simplified version of it, it just comes down to associations, like the vocab list that I went over. If you actually know every word on that vocabulary list, then it'll be easy to associate those things, right? Another one is something that I try to make students do, and I'll do more when it gets down to it, which is put people on the spot. People don't give me credit. I mean, I don't care, whatever. I don't fucking care. But like, when I am up here and I'm just speaking, no notes, I watch other professors, they're just reading off of a script. Like, I'm just up here answering questions, talking, speaking, and that's a really difficult thing to do. But for me, I've very much normalized it. And how? Mastery of the material. There's no way I could get up here and give a presentation on like newest fashion trends in America. Like, it's not my lane, right? But if it's something that I really understand, that I'm really like, I know well, I can just tell by talking to a lot of y'all. A lot of y'all really follow football or soccer or whatever. If you know the material like that, then the associations become quick. You'll read an article and be like, Michael Jordan, and you'll immediately be like, 6-time champion Michael Jordan, who played with Scottie Pippen and Dennis Rodman, who went to North Carolina. Like, you know what I mean? Like, if you know about the subject matter, the associations come up really quick. Now, at whatever age most students are, I can't really train that effectively. I mean, I can a little bit if I have a lot of time with you, but like reading comprehension and reading speed and neurological associations, those are things that hopefully people have been developing from childhood. And it's just it is reading comprehension. Like, you want to read very carefully, very focused. Like, everyone has ADD, ADHD these days to some extent. I'm not trying to diminish anyone's who has it severely, but it's hard to focus. But when you're doing these questions, you really do need to focus and like read the words carefully. Every sentence has a purpose. I mean, I think it's very poetic, you know, remember the words are written for a reason. I get messages all the time from students who will be like, question 4 from, you know, quiz number 7 has one word that doesn't make sense. And then I'll message whoever wrote it on my staff and be like, bro, like we fix it. You can't do this. Every word is important. And it's the same way when you're taking the test, like every word has a purpose. They wrote in those questions that there's no marketable title that was expressed. They wrote that specifically to throw you off so that you would register it and think about it and be like, okay, that doesn't have a purpose. Then they specifically said Tommy sued under breach of contract. You have to be able to associate breach of contract when you're talking about a deed defect would implicate merger. That just has to be an association. I mean, it's again extremely complex for me to teach that. I will say, if you have children and you sign them up with Ibis Prep at a very young age, we can train them by the time they take the bar exam to be really efficient at that. But I do think it's a lifelong skill, which is reading comprehension and association. All right, cool. So I appreciate that question. But Victoria, do you mind sharing the screen? And I'll pull up the first poll. Let's get into some practice questions because real property are dense, if you will. All right, I don't need to do who's going to win versus the Packers versus the Eagles. We know that eagle is an elegant bird. If you see, if an eagle is flying at its highest altitude and sees another bird, it must be another eagle because no other bird could fly as high as an eagle. So, you know, it's a good thought about eagles. I don't really know much about meat packing. I feel like it's probably very gruesome and led to a lot of sadness over the years. All right, let's look at this question. So who is likely to prevail? And we have the businessman versus the cousin. So a businessman owned 2 adjoining tracts of land. One was improved with a commercial rental building and another that was vacant and abutted a river. 20 years ago, the businesswoman, I'm sorry, I called it a businessman. A businesswoman owned 2 adjoining tracts of land, one that was improved with a commercial rental building and another that was vacant abutted a river. 20 years ago, the businesswoman conveyed the vacant tract to a grantee by a warranty deed that the businesswoman signed, but the grantee did not. I don't think that's going to have too much of an impact. See, that's what I'm saying. Then you got to think about each sentence as it comes across like that. I'm like, all right, I don't think that has too much of an impact. Maybe it does, maybe it doesn't, but on first read, I don't think it does. The deed contained a covenant by the grantee as owner of the vacant tract that neither he nor his heirs or assigns would erect any building on the vacant tract in order to preserve the view of the river from the commercial building on the improved tract. So we have a real covenant here. The grantee intended to use the vacant tract as a nature preserve. The grantee promptly and properly recorded the deed. Last year, the businesswoman conveyed the improved tract to a businessman. A month later, the grantee died, devising all of his property, including the vacant land, to his cousin. 6 weeks ago, the cousin began construction of a building on the vacant tract. The businessman objected and sued to enjoin construction of the building. So like on first glance, like the issue that we have to look into, and then I'm going to read back over this, y'all going to read back over this too, is the construction of the building would seem to violate the covenant that you couldn't erect any building, right? So we're gonna have to figure out if that's okay or not. So who is likely to prevail? The businessman, because the commercial building was constructed before the cousin began his construction project. The businessman, because the cousin is bound by the covenant made by the grantee. The cousin, because an equitable servitude does not survive the death of the promisor, or the cousin, because the grantee did not sign the deed. So everyone take a, minute or so to consider this question. And if you need Vic to scroll up or anything, just let her know. Okay. Any last thoughts? Okay. So it seems to be a very heavy favoritism towards B, as in basketball. Any thoughts? Icky Vicky, you agree?
Yeah, that's what I had chosen.
All right, let's run it. B is correct. The businesswoman and grantee create a valid equitable servitude. The promise was in writing, the deed that satisfied the statute of frauds. The promise restricting the use of the vacant land touched and concerned the land, placing a burden on the vacant tract and giving a benefit to the improved tract. The writing showed an intent that the promise would be binding on the grantee's heirs and assigns. The grantee recorded the deed. The cousin had constructive notice of the equitable servitude and is bound by it because nothing has occurred that would terminate the equitable servitude. So some people pick C. C is incorrect. An equitable servitude will not end on the death of the promisor, absent a provision which provides so. So, what I'm gonna do, as may or may not know, is continue to update this cram guide. So, Victoria, yeah, I put the link in the chat, or you already have it right there. Yeah, you can go to classwork. It's right at the top. Yeah. You're getting really good at this. It sucks that you're gonna pass this test and then I'm gonna have to find a new van and wait for July. I've been thinking a lot about my business, and like a lot of states are switching to next gen bar in 2026. So obviously, me being the freakazoid that I am, I'm gonna take the next gen bar in 2026. And there's like 6 jurisdictions that I can take it in. Everyone appeals to me except for Missouri, but maybe Connecticut or Guam or Washington or Oregon or Maryland. Those are the states that are taking it. So I gotta pick which one of those states. I'm kind of leaning towards Guam just because for the plot, you know? Okay, can you can you share the thing?
Can you see it? I tried to split my screen. Did it work?
All I see is um all I see is you and the screen.
You don't, okay, wait, hold on. I tried to,
Maybe oh
Here?
yeah. Now I can, but it's like kind of zoomed in. Okay, yeah, now I can. All right, bet. So if everyone sees today, we did con law. Before that, we did not today, but we've previously done con law, torts, and contracts. Today, we're gonna do real property. What do you think? What was the difficulty meter on this question, Vic?
honestly, I think baseline property is probably the hardest subject MBE, so,
I would disagree with you.
oh, well,
I would say it's the second hardest. I think civ procedure is actually the hardest. Civ pro is tough. But it's hard. It's definitely second hardest. I didn't mean to be like, I'm really not trying to pick on your ability. I didn't mean that. I was just saying I disagree with you. Okay, but
this coming week, no?
what's up? Civ Pro's next week. Yeah, it's like the little gauntlet I do. Real property, Civ Pro, back to back. You know. Okay, so the takeaway from this question is I like what C said, that an equitable servitude will not terminate upon the death of, who did they say, the death of the promisor? Okay. Absent a provision otherwise, and say equitable servitude will run with the land if there is notice, intent, and it touches and concerns the land. We go with that?
Mm-hmm.
All right, bet.
Next.
Next.
And
Oh, did everyone see the
you-
result?
Can you scroll down a little bit just to see on the Google? Yeah, thank you. Sorry.
No, you're good. Pretty good. 83%. 83%. All right, let's see. Sometimes my launch polls, they actually are about like which team is gonna win, but I'm confident in the Eagles today, which could be a bad thing, but hopefully not. All right. Wow, this is one whole question. Okay.
Yep.
Jesus Christmas. Okay, the age of majority in this jurisdiction is 18 years old. The owner brought appropriate action against the fiance. fiancé to quiet title, can't even read, against the fiancé to quiet title to Rich Acre. So the owner brought an appropriate action against the fiancé to quiet title to Rich Acre. So who's gonna win? Can you scroll down a little bit? It's the owner or the fiancé. I mean, isn't fiancé supposed to have a little tilde on it?
Hmm.
Right? Or no? Okay, never mind.
Yes, it does.
It does, right?
Correct.
Okay, because I'm like, why do I not know how to read this word? Like, I'm sorry. Okay, can we scroll up, please?
I think it's because there's another question that says like financier.
Yeah, financier. Well, that's what I was like, which is kind of in between fiance and a financier. Whatever. It's fiance. It's whatever. It's really not important. And on test day, honestly, I've taken the bar exam where there's grammatical mistakes on questions, and like, what can you do? You know, the test is going on. You can't like, excuse me, like there should be a period here. So let's just not get obsessed with it. Okay. So what's going on? The owner or the fiancé? The owner in a fee simple Rich Acre, a large parcel of vacant land, executed deed purporting to convey Rich Acre to her nephew. The owner told the nephew, who was then 19, about the deed and said that she would give it to him when he reached 21 and had received his undergraduate college degrees. Shortly afterward, the nephew searched the owner's desk, found and removed the deed, and recorded it. Okay, so sneaky little nephew, right? He was told about a deed, but he went and recorded it on his own. A month later, the nephew executed an instrument in the proper form of a warranty deed purporting to convey Rich Acre to his fiancée. He delivered the deed, reciting that it was given in exchange for $1 and other good and valuable consideration, and explained that to make it valid, the fiancée must pay him $1. The fiancée, impressed and grateful, did so. Together, they went to the recording office and recorded the deed. The fiancée assumed the nephew had owned Rich Acre and knew nothing about the nephew's dealing with the owner. Neither the owner's deed to the nephew nor the nephew's deed to the fiancée mentioned anything about any conditions. So it seems like here the nephew purported it to the fiancée for $1, and the fiancée paid him $1. I don't even, well, whatever, it's not my question. The Recording Act of the jurisdiction provides no conveyance or mortgage of real property shall be good against subsequent purchasers for value and without notice unless the same be recorded to law. What type of jurisdiction is this?
Who notice?
Pure notice, right? And how did you know that?
Notice.
Yeah, it just says that shall not be good against subsequent purchaser for value. So that's a BFP. And it doesn't make any mention about first recording.
It does exactly. So that's the other thing you were looking for was did say who was first to record, but it doesn't say that. It just says pure notice. Okay, 2 years passed. The nephew turned 21, then graduated from college. At the graduation party, the owner was chatting with the fiancée and for the first time learned the foregoing facts. The age of majority in the jurisdiction is 18 years old. The owner brought an appropriate action against the fiancée to quiet title to Rich Acre. So the court will decide for whom? The owner, because the nephew's deed to the fiancée before the nephew satisfied the owner's condition was void, because the fiancée was paid only nominal consideration. Can you scroll down, Vic? The owner, because her deed to the nephew was not delivered. The fiancée, because the nephew has satisfied the owner's oral conditions, or the fiancée, because the deed to her was recorded. Vic, you might need to scroll up for some people.
Mhm. Like hard to put everything in.
No, you're doing amazing.
Vicky, could you just scroll down a little bit so I could see the answer choices? Thank you.
Can you scroll back up just a tiny bit so I can see the top of the question?
Oh, good.
Thanks.
A couple people are texting me to ask me if I'm doing the boot camp live this year. I've done it live the past 3 years. I was planning on only doing it virtual this year. As of right now, I'm only doing it virtual, but if enough people, I don't know. As of right now, I'm only doing it virtual. These students annoy me too much live. And with all love and respect and honesty. And it's not the majority of the students, it's the minority. You know, one bad ingredient can make the whole recipe go wrong. All right, any other answers?
I think this is a perfect example for Diana's question, this kind of almost like essay-like question. There
Oh,
is
one thing did pretty much hint at it. Did you see like what was important? Did anyone see what was like a very important piece? I think Vicky, if you highlight the nephew at the way beginning, the owner told the nephew about the deed and said he would give it to him when he was 21, right?
That's what stuck out for me in the beginning.
That's what stuck out to me too. What is that? What's the importance of that statement?
It's not a present intent to transfer, which is a requirement of delivery.
Yeah, I don't think it was
It
delivered.
wasn't delivered.
Yeah, so I don't see the
the
delivery, yeah.
yeah,
That's what the majority of people are saying. Is that what you picked, Vic?
Yep.
could be.
B as in basketball? Let's get it. So B is correct. Intent rather than mere physical possession is determinative with regard to the purported delivery of a deed. In this case, it is clear from the facts that the owner's intent was that title would not pass to the nephew until he reached age 21 and had earned a college degree. The nephew's physical possession of and recording of the deed, contrary to the owner's intent, does not negate that intent. Therefore, the deed was never delivered to the nephew. Fair enough. So some people picked A, B, and C. A is incorrect. Consideration is not required in relation to delivery of a deed. That's what I was saying. I didn't like that $1 thing. C is incorrect. The failure of delivery, not the failure of condition that negates the nephew's conveyance. It's the failure. D, the fiancee's recording of a deed that was never delivered to the nephew is inadequate to secure an ownership interest in the property. So it was never delivered. So it's pretty cool stuff. It says BFP, you know, is one who gives valuable consideration and has no notice of prior instrument. And every deed should contain the following information: an indication that is a deed, a description of the property involved, the signature of the individual or entity that is transferring the property, and data regarding who is taking title to the property. So yeah, that's pretty cool. Anyone have any questions about this one?
There's the one thing about the BFP. It has to be valuable consideration. $1 is not enough to be equivalent of valuable consideration. That sometimes it cannot be a bona fide purchaser if it's not the equivalent of the price for what they're paying for, right? So paying $1 also triggers that it's not a bona fide purchase, although that's not the issue here. As a general idea for another question.
So I like, in order for a deed to be delivered, there must be intent. For example, if a person says to nephew that he will deliver a deed in the future. And before that date, the nephew steals the deed and records it, there has never been delivery.
Andrew, I would just add the in front of intent, the present intent, just to make it clear.
Perfect. All right, let's do another, un otro.
Mhm.
So Vicky, what's your favorite song on a Bad Bunny album? Since that's what you're so,
I think Baile Inolvidable is the best song on the album, but I mean, there's a bunch I like.
that's
Like,
good. That's
yeah.
good. Yeah, good music to keep you through your studies, right? It's good
Mhm.
study music. Okay, can you like, I mean, yeah, exactly. So 20 years ago, okay, so who should the title be for? Developer, son, friend, or school district? 20 years ago, a testator who owned Blackacre, a 1 acre tract of land, duly delivered a deed of Blackacre to the school district so long as it is used for school purposes, so long as it is used. The deed was promptly and properly recorded. 5 years ago, the testator died, leaving his son as his only heir, but by his duly probated will, left all my estate to my friend. Last month, the school district closed its school on Blackacre and for valid consideration, duly executed and delivered a quitclaim deed of Blackacre to a developer who planned to use the land for commercial development. The developer has now brought an appropriate action to quiet title against the testator's son, the friend, and the school district. The only applicable statute is a provision in the jurisdiction's probate code, which provides that any property interest which is ascendable is divisible. In such action, the court should find that title is now in developer, son, friend, or school district. Okay. Yeah. Good question. I was about to like go through it, but you know, you guys figure it out. Need a new poll, my bad. Okay. All right. Any last thoughts? I know countdown. Most people are actually getting it right. Are you guys cheating? Or am I just that good at teaching? Did Marion teach this week or what? I agree with C. You agree with C, Vic?
Mm.
Okay, why C? Because it said that, yeah, the testator left all of his estate to the friend. And why would it go to the testator? Because it said so long as it's used for school purposes, but then they stopped using it for school purposes, right? They
Mhm.
closed the school. So when they closed the school, it reverted. Then when it reverted, testator died, descended to friend. And it said right there, anything that's divisible is descendable. Or is that a previous question? No, it did say that. Any property which is descendable is divisible. Yeah. So it was divisible, divised to the friend. Or descended to the friend. I like C. In this case, the school district interest was a fee simple determinable, meaning it could be terminated, and the testator's interest was a possibility of reverter. According to the facts, the only event that could terminate the school district's interest would be to cease using the land for school purposes. When that event occurred, the school's interest terminated, the land reverted back to the testator. The testator, however, had died by the time the interest reverted, so that interest went to the friend in accordance with the dictates of the testator's duly probated will. So I like that.
Mhm.
So a fee simple determinable will automatically revert upon the occurrence of a stated event. Okay, so for example, a devise that goes to A so long as property is used for church purposes will automatically revert back to A when property is no longer used as a church and will go to A's heirs if A is deceased. That makes sense to everyone? Here, the heirs were the will, right? The friend was pretty much the heir in that sense. Is devise not a word? I think it is.
No, devise is a word, D-E-V-I-S-E. It is a word.
Yeah, that's what I was. Whatever. AI's getting better. All right. Do you remember the first AI? The first AI besides Ask Jeeves? It was Ask Jeeves, and it was the paperclip.
Yep.
Yeah. That paperclip was definitely the first AI. Okay, so let's do another one. Like for DJ Khaled. Class is doing pretty good. So far, so good. Is anyone 3 for 3? You are, Ashley? That's amazing. Anyone else? You are, Heather? 3 for 3? Must be, you know,
I like property question, so.
that's good. Yeah, I mean, I don't know, property stuff. It's not, yeah, CJ says 3 for 3. I mean, are you raising your hand because you have a question? Or raising your hand because you're 3 for 3, CJ? 3 for 3. Man, my dog.
I
is
also worked in this area of law, probate and trust estates, so it just resonates with me a bit more than other
And
areas.
you've done well on previous tests, right? In this section compared to others?
Yeah.
Yeah, that's good. You gotta make your strength stronger too, though, you know, even anyone can get better. Like, there's no subject that anyone gets every single question in. So let's try to stay locked in, but I like that. We have some experts in the room. All right, so what would a court find for the owner or the cousin? An owner contracted to sell Blackacre to his cousin. The written contract required the owner to provide evidence of marketable title of record, specify a closing date, state that time is of the essence, and provide that at closing, the owner would convey by warranty deed. The cousin paid the owner $2,000 of earnest money towards the $40,000 purchase price. What are they buying for $40,000? The title, not in Florida, right? The title evidence showed that an undivided 1/8 interest in Blackacre was owned by a woman. Okay, so the woman had an interest. That's not good. The cousin immediately objected to title and said he would not close on the owner's title. The owner responded accurately that the woman was his daughter who would be trekking in Nepal until 2 weeks after the specified closing date. He said that she would gladly deed her interest upon return, and that meanwhile his deed warranting title to all of Blackacre would fully protect the cousin. The owner duly tendered his deed, but the cousin refused to close. The cousin brought appropriate action to recover the $2,000 earnest money promptly after the specified closing date. The owner counterclaimed for specific performance, tendering the deed from himself and the woman who had by then returned. The court will hold for the owner because the woman's deed completing the transfer was given within a reasonable time. The owner because his warranty deed would have given his cousin adequate interim protection. The cousin because the owner's title was not marketable and time was of the essence, or the cousin because under the circumstances, the earnest money amount was excessive. A lot of uniformity here. All right, any further thoughts? Participation is low. It seems that most people pick C. What's up, Rosie? You're sick of barking at the neighbor's dogs? You pick C too, Vic?
Yes.
Rosie, come here. Rosie, come here. Come here. Why is it C, Vicky? You want to read the answer choice?
Yeah. In general, seller is required to provide marketable title on the closing date. Where the sale contract does not indicate that time is of the essence, however, the seller's performance need only occur within a reasonable time after the scheduled closing date. As such, a buyer under that contract will not be able to rescind or seek damages until that reasonable time, sometimes as much as several months has passed without the seller providing marketable title. In contrast, where the contract does indicate that time is of the essence, whichever party fails to perform by the scheduled closing date loses their right to enforce the contract. In this case, the contract indicated that time is of the essence and the owner failed to perform by the scheduled closing date, so the cousin will prevail.
Perfect. Rosie's not the best laptop. So yeah, here the reason why time was of the essence was literally because time was of the essence. So
Because it's expressly stated it in the contract. If it didn't, then time is not considered of the essence.
right, stated in a land sale contract, then it will be valid. Otherwise, there is a reasonable time to close after the agreed upon date. Fair enough. Like usually you don't have to do on the exact closing date, but if they do say time is of the essence, then time is indeed of the essence. All right, let's do another one.
Are we adding the takeaway on this one too about the marketable title? Like they didn't have marketable title when it was going to close, when they were going to close, because the person owned 1/8.
Yeah, so I could say, for example, if the contract, well, I mean, marketable title is always required, but if the contract required marketable title,
Right, but in this particular question, there wasn't marketable title because
I know.
Yeah.
So for example, if the contract required marketable title, which is implied anyway, and the seller cannot deliver marketable title by closing date and time was of the essence, the buyer could rescind the contract. All right, fair enough. Okay, so another one, let's get it. So the most probable result here will be for returning a certain amount of money. So 3 months ago, a buyer agreed in writing to buy a property owner's single-family residence live acre for $110,000. The boner, the buyer paid
That was crazy.
Bro, that was crazy. I was saying buyer and owner. That was crazy. Let's start that over. Let's start this whole question over. That was crazy. 3 months ago, a buyer agreed in writing to buy a property owner's single-family residence, live acre for $100,000. The buyer paid the owner a $5,000 deposit to be applied to the purchase price. The contract stated that the owner had the right at his option to retain the deposit as liquidated damages in the event of a buyer's default. The closing was to have taken place last week. 6 weeks ago, the buyer was notified by his employer that he was to be transferred to another job 1,000 miles away. The buyer immediately notified the owner that he could not close, and therefore he didn't. I can't fucking do this. I'm sorry. The buyer immediately notified the owner that he could not close, and therefore he demanded the return of his $5,000. The owner refused, waited until after the contract closing date, listed with the broker, and then conveyed live acre for $108,000 to a subsequent purchaser found by the real estate broker. The subsequent purchaser paid the full purchase price and immediately recorded his deed. This subsequent purchaser knew of the prior contract with the original buyer. In appropriate action, the original buyer seeks to recover the $5,000 deposit from the owner. And the most probable result will be that the owner must return the $5,000 to the original buyer because the owner can no longer carry out his contract with the original buyer. Must return the $5,000 to the original buyer because he was legally justified in not completing the contract. Must return $3,000 to the original buyer because the owner's damages were only $2,000, and must keep the $5,000 deposit because the original buyer breached the contract. Tamara, did you find the poll, by the way, that disappeared? I think it was just my fault earlier.
I have a feeling this session's probably not getting posted to YouTube.
I don't know, man, because Rachel was supposed to post the YouTube videos. She wasn't able to post them. So I was like, all right, whatever, I'll post them. So I've been going back and I just started, like I posted the first one this morning, but it's from contracts. So like, I'm not even picking and choosing based on content. It's kind of random. So it could very well be this one, the buyer owner. And Vic, you had to immediately be like, that's crazy. Like you could.
This question is gonna have a lot of mixed answers, I have a feeling.
there's only one right answer.
I know, wow. It's always in front of you, right?
Like that happens to sports announcers all the time, but like that's a crazy one. But you could see it was 2 words that were like right next to each other, like the buyer owner, and I was reading really fast. Oh my god.
And you had a long weekend. You've been teaching a lot. You need a little break.
Yeah, for sure. I appreciate you, Tamara. You're so sweet. All right, most people are picking the same answer. I think we like that. Anyone have any other thoughts? We can move on from this question.
We need to, yeah.
I have what's called like, I forget the word, there's some scientific word where like your blood vessels are close to your cheek, so I get embarrassed, it's like I'm probably super red right now. Like a tomato.
Ooh.
Yeah, most people pick D. Is that what you picked, Vic?
Nope.
D is correct. The buyer breached the contract and the parties agreed upon liquidated damages clause that allowed the owner to keep the 5,000 be upheld by the court as it's less than 10% of the purchase price and not a penalty. So yeah, a liquidated damages clause may be upheld in a land sale contract so long as it is reasonable and not a penalty. A deposit, for example, is a typical type of liquidated damages that a seller may be able to retain. Fair enough?
Mhm.
All right, cool. Next question. That's the best thing about the MBEs. It's the next question. Oh my God, this is a long question. Can we skip this question?
Yeah.
Honestly, thank you. I'm sorry. Oh my, well, that's what we needed. That's literally just what the doctor ordered. Okay, so if the nephew sues the niece for contribution, who will likely prevail? A nephew will be the nephew or the niece. A nephew and a niece inherited vacant land. The nephew soon discovered that the land was subject to a mortgage held by a local bank, which required monthly payments for the next 10 years. Without telling the niece or seeking her permission, the nephew made the monthly mortgage payments for 1 year. The nephew then demanded immediate payment from the niece for half of the mortgage payments he had made. The niece refused. If the nephew sues the niece for contribution, who will likely prevail? The nephew because of the doctrine of exoneration, the nephew because without his payments, the bank could have foreclosed the mortgage and could have lost the land, the niece because any such payment is not due until a partition proceeding is held, and the niece because the nephew did not seek or obtain her consent before he made the payments. The truth is, Eric, this probably would do better on YouTube, right? Like I had one video on YouTube where I didn't realize I posted it. People are like, why'd you post that? I'm like, I don't know. I gotta delete it. But they said that, entertaining. Anything can happen with live TV, anything. My dogs got in a fight last time. Poor Biscuit. They're fighting over food though. I had this one student, Richard, give me the middle finger. I don't think anyone was here for that. That was long ago when I first started. He gave me
Is
the
it a
middle
joke
finger.
or out of anger or?
No, out of anger. But he liked me. It's one of those love-hate things. He didn't hate me. He was just mad at the situation. Because I used to have a lot of guest tutors speak. I do it less often, and now when I do it, it's more vetted and more whatever. So I had this one guest. I used to have like my other tutors do lectures. And if they were ever like unsure about something or whatever, like he would attack them and be like, well, actually, rule 557, and and I'd be like, bro, you failed this test like 100 times by now. Like, you're not the one to like be attacking my tutors who have passed it. But anyway, one time he was going on one of his little diatribes against one of my tutors, and I muted him. I put the mute because I have the power to mute people. So I muted him as he was talking, and then he hit me with the middle fingers and exited the room. Yeah, that's a real story. I got stories for days in this bar prep business. I like Richard. I would not be surprised if he was still taking the bar to this day. I'll see you in February. He's not a good test taker from what I gather. Yeah, I don't think I'm gonna put this one on YouTube. I'm gonna try not to. The real profit. Although I like to put these ones on the workshops to showcase. Anyone have any other thoughts? I think the majority is pretty right here. It's looking good. I feel like this administration is going well. Most people are picking B. I agree with B. Like they would have foreclosed if they didn't pay, and like someone had to do it. She's gonna have to get it back. It's kind of like the one we did at the beginning of class with the surety. They're not sureties here, but they are co-tenants. And that's true. Like if they both have the obligation and one of them pays it, then they have the right to recover. You like BVIC?
Yeah.
Have you been getting them all right too?
Yeah, I got like the first one wrong, I think.
The first one wrong, which was about
The equitable servitude. I've been
oh
working.
yeah, true. You thought that it expired, it terminated because they died?
Yep.
That's fair enough. All right, let's see what we got here. So B is correct. The nephew and the niece inherited the vacant land as tenants in common. While neither is personally liable on the mortgage, their failure to pay could result in a foreclosure. To avoid foreclosure, payment must be made to the bank, and as co-tenants, each is responsible for his or her share of the mortgage payment. The nephew paid more than his prorated share, may recover the amount owed by the niece in a contribution action. So I like that. So a contribution action when one tenant makes mortgage payments and can recover pro rata from the other. I think that's kind of fair enough and self-explanatory. Okay, let's continue. I like this split screen thing. My mobile app's about to come out again. It's been a long time coming, but I've been working on it. I've learned one thing. I'm not like, this is just factual. Do not take this in the wrong way. It's just something factual. But this is like the third team I've worked with on building a mobile app. And somehow all mobile application builders I've worked with, the actual builders are in Pakistan. Like no matter if they're in New Jersey or they're here in Miami or whatever, like the actual people who are doing the, IUU export are in Pakistan. It's 3 for 3 now. I'm just saying that's like nothing. That's probably a good thing for Pakistan. I'm just saying that's what I've learned.
Are you working with Fiverr? Fiverr people?
No, I don't even get me started on my app. I
It's
started
the best website to find the cheapest people.
really Fiverr.
Fiverr, yeah.
I started with this company AppsNato that was referred to me. They built the app for me, but it just didn't go that well. So then I switched it over to one of my instructors, like his team in Pakistan. But I think it's all good. I like Pakistan. Pakistan's one of my roommates in college is from Pakistan. He's a man. I went to his wedding and I wore the whole garb. That's not the right word, but I don't know. Okay, so let's talk about this businesswoman. Businesswoman or religious group. So the most likely result in this action is the court will hold for whom? Blackacre is a large tract of land owned by a religious group. On Blackacre, the religious group erected a large residential building where its members reside. Blackacre is surrounded by rural residential properties, and its only access to a public way is afforded by an easement over a strip of land 30 feet wide. The easement was granted to the religious group by deed from a businesswoman, the owner of one of the adjacent residential properties. The religious group built a driveway on the strip, and the easement was used for 20 years without incident or objection. Last year, as permitted by the applicable zoning ordinance, the religious group constructed a 200-bed nursing home and parking lot on Blackacre, using all of Blackacre that was available for such development. The nursing home was very successful, and on Sundays, visitors to the nursing home overflowed the parking facilities on Blackacre and parked all along the driveway from early in the morning through the evening hours. After 2 Sundays of the resulting congestion and inconvenience, the businesswoman erected a barrier across the driveway on Sundays, preventing any use of the driveway by anyone seeking access to Blackacre. The religious group objected. The businesswoman brought appropriate action to terminate the easement. The most likely result in this action is that the court will hold for the businesswoman because the religious group excessively expanded the use of the dominant tenement, the businesswoman because the parking on the driveway exceeded the scope of the easement, the religious group because expanded use of the easement does not terminate the easement, the religious group because the businesswoman's use of self-help denies her the right to equitable relief. I see, Vic, you couldn't wait to tell Nat about what I said in class.
I can't keep things from her, you know?
You think that me and Tamara are a thing? Do you hear that, Tamara?
No, I missed it. What is it?
Nothing.
Now I'm curious. What is it?
No, nothing. No, it's nothing. You have to ask Vic what she thinks. I didn't say anything. I was just repeating her thought.
What did I miss? Now I have to see the recording of this.
Yeah, this is definitely going on YouTube. What did you say, Vic? You just say to the class.
I think that she's your new favorite student. That's it.
True, yeah. I already told you.
Victoria, well, we'll agree that for all good reasons, he's been paying more attention to you. And if, my dear, you want to take a relief, we can help you a little bit, all of us.
Yeah, what is going on? All right, so are you guys picking the right answer?
There's too much tea for me to concentrate.
You're the one. I'm just looking at my phone. I'm trying to schedule lunch or dinner with my uncle, literally. He's back in town. My uncle's born
Think
and
about how
raised.
easy it's gonna be to answer questions during the exam when you don't have like all the
Yes.
awkwardness flying around.
Hey, there's some weird stuff that happens in the exam. There's some smells, there's some crunches, there's some odors, there's some noises. Like, I didn't realize until I took bar exams how much noise people's bodies make. Like, just in, like, they're like cars that just like.
Take that over social tension all day, man.
Yeah.
Someone sneezed like 8 times in a row during one of my sessions once.
Oh, I heard about the super sneezer. I heard about the super sneezer. Yeah, that's definitely a thing. When I took in Pennsylvania, allegedly someone like threw up and was like constantly throwing up during the test, but like refused to like not do it. All right, so Yasmin saying there's a bird inside that was pooping on people. Yeah, we're getting some good stuff. All right, let's see. So most people are picking C here. Is that what you thought, Vic? Not really? Did you think C? You did?
I was still getting through the question. I was rereading
Oh
it.
shit, my bad.
No, it's okay.
I don't think it's it would be terminated. I think they would be an injunction or a surcharge or something, but I don't think expanded use, like just looking at the answer choices, I like C. I got
Okay.
distracted too, but I like C. Yeah, C is correct. Although the nursing home has an increased use of the easement on one day of the week, such use will not terminate the easement. Where the holder of the dominant state misuses an easement by excessive use, the serving holder's proper remedy will be injunction against further misuse or damages, not forfeiture of the easement. So, that comes up on essays too, that like overuse of an easement does not lead to termination. Rather, it calls for injunctive relief or a surcharge. Does that resonate with everyone? That's fair enough? I don't know who I got that from. Fair enough. I guess I'm like things. I was in sales for a while. I'm going to teach about sales next week in my networking group. Some sales lingo. Here's one thing I'm going to teach the group. Okay. So for instance, me and my uncle are meeting for lunch. Let's say we could meet in Coral Gables or we could meet in Coconut Grove. Whichever place I wanted to meet, you ask second. So I say, hey, Steve, let's say I want to meet in the Grove. I say, hey, Steve, we could have lunch in the Gables or we could meet in the Grove. Whatever's better for you. Naturally, people will pick the second option. That's something I learned in the sales world. So if you want someone to do something out of two choices, present it and then tell them the second option and kind of stop big. Or we can do the thing that I actually want you to do. Okay. Just a thought. I was taught to me, and don't quiz me on that. All right. So for whom is the court likely to decide? For the cousin or for the friend? A man conveyed land by quitclaim deed as a gift to his cousin, who did not then record the deed or take possession of the land. 6 months later, when the man was still in possession, he conveyed the land by quitclaim deed as a gift to a friend who knew nothing of the deed to the cousin. The friend did not record his deed. So we got a bunch of non-recorders here. The man then vacated the land and the friend took possession. The recording act of the jurisdiction provides as follows. So I want everyone to get really good at identifying what type of jurisdiction we're in. No unrecorded conveyance or mortgage of real property shall be good against subsequent purchasers for value without notice. Who shall first record? So this is going to be a
Grace notice.
Exactly. Good work. Recently, the cousin learned about the friend's deed in possession, immediately recorded her deed, and sued the friend for possession and the quiet title. The friend then recorded his deed and raised all available defenses. For whom is the court likely to decide? For the cousin, because she was not first in time and the friend was not a purchaser. For the cousin, because the friend failed to first record. for the friend because a subsequent good faith donee has priority over a prior donee who fails to record, or for the friend because he was first in possession? Take some time to read over this one. I actually recall this being a tough question. All right, I think we're gonna have our first great debate. I could be swayed here. I mean, I knew this was a hard question. Anyone else have any other thoughts? Any cheeseheads out there? All right, so A, B, and D seem to be the contenders. Does anyone want to argue why they think A might be the right answer?
I think A is the right answer because I was between A and B. And after rereading the facts, what made me determine A was that the friend was not a bona fide purchaser, because even though the beginning of the language in the sentence made it seem like it, what really stuck out to me was that the quitclaim deed was a gift to the friend. And I remembered, like, bona fide purchasers, usually when something's given as a gift, that's not like an actual exchange, because it has to be like they gave value for the property, not just like you received it as a gift.
Right, I like that argument that the friend was not a purchaser, so they wouldn't prevail under the recording statute because it said it's only against subsequent purchasers for value. And it says who shall record first, and for the cousin says they recorded first, so A kind of addresses the statute. Does anyone want to argue why they think B is the right answer?
It was B because, I mean, neither one of them is a bona fide purchaser, right? So the first to record, that kind of brings the race aspect into this. So the first to record would take.
Or, and then does anyone want to argue? So you're saying that B is the better answer than A because neither of them were
Yeah.
bona fide.
It doesn't matter who is first in time, it just matters who first records.
Right. Okay, that's an argument. So, and then what about D? Does anyone have an argument for D?
I do, I have. So I totally agree with Gabby and Eric, but I think the exclusion applies in here because, he was in possession, the friend was in possession, and he could have a valid point that he might be the one.
I'm sorry, can you say again?
I said the exclusion might apply in here because the friend was in possession of the land.
Okay, so because the friend was in possession, you're saying that that would give them title. So it's an action to quiet title. I don't really think that
Okay.
possession would be the key piece here. I do think we're gonna have to look at the recording statute, and it's gonna be, you know, who was the first to record and if they're going to be protected. Now, between A and B, it's interesting. I'm like kind of considering this now. Does it matter that they were not a purchaser or not? I honestly
I
lean
don't
towards.
think so. That's why I chose B, was I don't think it matters that if they're a purchaser or not. I think it's the recording issue.
So a man conveyed it by quitclaim deed as a gift to the
But
husband.
it's not like in a bad faith because the cousin that's what like the only thing that threw me like like I said no for cousin was that because it kind of acted in bad faith as soon as he learned that the friend took possession of the property, he went and then he recorded.
For bad faith though, because he received his deed first, so he's really just trying to protect himself at that point. So it's not really bad faith; it's more just, being prudent.
Well, the reason that I think, I mean, I'm considering this, but I think it might matter if he was a purchaser. Because if the friend was a purchaser, then the cousin
he would've-
recording wouldn't cut off his rights because you have to be a purchaser and be the first to record. So between those two answers, I'm kind of leaning towards A because I think it does matter. I see what you're both saying. I feel like the cousin would prevail here because the cousin recorded first and the friend was not a purchaser, because if the friend was a purchaser, a bona fide purchaser, then the cousin recording first still wouldn't be enough, because then the friend could just go record and then the friend would be the first bona fide purchaser to record. That's kind of what I'm thinking here. Whereas if the friend recorded even at second, but the friend was a purchaser, then wouldn't the friend win?
So
So what
when they
about
say
the-
because she
under
was
the
the first
shelter
in
rule?
time.
Go ahead.
Sorry, Heather. Go ahead.
Go ahead, Heather. Go ahead.
I was just thinking under the shelter rule that it protects anyone who takes their interest from a bona fide purchaser. That includes donees, heirs, and deposees. So a donee would be a gift, right? So
Yeah,
they
but there's
stand in
no-
the shoes of the BFP, but so the man, I mean, I suppose was a BFP the cousin took from.
Well, you don't know. I mean, you don't know if the man is a BFP. I mean, I think that's too much to assume. But even if that was if that was the case, then yes, the cousin would be a bona fide purchaser. I mean, in that sense, and even so, it would still be important if the friend was a bona fide purchaser who prevailed. I mean, it's a thought. And then what were you saying, Steve or Eric? Sorry.
Oh, you're fine. So in A, I have a question about what they mean when they say first in time. Are they referring to first in time in terms of receiving the deed, or first in time to record? Because that's where I was getting like leaning towards B. Is in A, they don't mention anything specifically about recording unless that's what they mean by first in time.
Yeah, first in time means to record.
Okay.
So yeah, it's first to record, and then it says the cousin immediately recorded the deed. So the cousin was the first to record. But here we're gonna protect bona fide purchasers who are first to record. I'm kind of leaning towards A. Vicky, what did you pick? You picked-
I was kind of in the B camp, but yeah.
Let's go with A. Let me get it wrong.
Okay.
Okay. A is correct. The statute in this question is a recording statute, more specifically race no statute. In this question, both conveyances to the cousin and the friend were conveyed by quitclaim deed as a gift. So I honestly do think there was merit to what Heather was saying. Like maybe the first man, you said, I assume he's a bona fide purchaser, but I think that's too much to assume. Like I hear what you're saying, but like you can't just assume that they're going to take shelter unless they specifically told you that the first party was a bona fide purchaser, because maybe they built the house or something. But anyway,
National average, how difficult is this question?
um,
Oh, yeah, 44%.
I mean, yeah. I mean, the reason why it's not that difficult comparatively is because it was between A and B for most people. There's some questions that are like, there could have been a good answer that was C too, that would have made it more difficult. But anyway, can you scroll up a little bit? I'm sorry. I want to read the answer, the actual answer. Okay, the statute in question is recording statute race notice. In this case, both conveyances to the cousin and the friend were conveyed by quitclaim deed as a gift. The friend did not pay value for the land, and therefore the friend is not a subsequent bona fide purchaser for value. The cousin will win because she was first in time, and the friend is not protected under the recording statute. B is incorrect. Here, the party who is first in time will prevail. Therefore, answer choice A is a stronger answer, right? They're just saying it's a stronger answer because the party who is first in time will prevail. And so I don't even really know how that helps us. So can you scroll down a little bit to why B is incorrect? B is incorrect. It's not enough that the friend did not record first. The friend was not a subsequent bona fide purchaser and is therefore not protected by the Recording Act. The party who was granted the property first will prevail because the common law rule will apply. Therefore, choice A is a stronger law answer. And what she highlighted is that common law in nearly all cases, priority is given to the grantee who received the property first. However, statutes known as recording acts require a grantee to make some sort of recording so as to give notice that title to the property has already been conveyed, to put subsequent grantees or purchasers on notice. Recording the deed is not essential to make it valid, but a grantee could lose on possession to a subsequent bona fide purchaser. A subsequent bona fide purchaser is one who gives valuable consideration and has no notice of the prior instrument. So A is correct. The statute in the question is recording statute, race notice. In this case, both conveyances to the cousin and friend were conveyed by quitclaim deed as a gift. The friend did not pay value for the land, and therefore the friend is not a subsequent bona fide purchaser for value. This means that the common law rule of first in time, first in right applies. The cousin will win because she was granted the property first, and the friend is not protected under the recording statute and was not a purchaser for value. So for me to kind of narrow that down for us, it means if there are two competing interests and neither party is protected by the recording statute, the common law rule of first in time, first in right will apply. For example, if two parties are donees, the party who received the property first will prevail in a race notice jurisdiction because the other party did not record and is not a bona fide purchaser. Really cheeky question. I mean, I don't love that question. I don't love the answer choices, but it is fair enough. All right, can you do another question, Vic? Okay. So, in that action, the court should what? So let's see. A brother and a sister acquired title and fee simple to Blackacre as equal tenants in common by inheritance from their aunt. During the last 15 years of her lifetime, the aunt allowed the brother to occupy an apartment in the house on Blackacre, to rent the other apartment in the house to various tenants, and to retain the rent. The brother made no payments to the aunt, and since the aunt's death 7 years ago, he has made no payments to his sister. For those 22 years, the brother has paid the real estate taxes on Blackacre, kept the building on Blackacre insured, and maintained the building. At all times, the sister has lived in a distant city and has never had anything to do with the aunt, her brother, or Blackacre. Recently, the sister needed money to run her business and demanded that her brother join her in selling Blackacre. He refused. The period of time to acquire title by adverse possession in the jurisdiction is 10 years. There's no other applicable statute. The sister brought an appropriate action against her brother for partition. The brother asserted all available defenses and counterclaims. In that action, the court should either grant or deny the partition. Deny partition and find that title is vested in the brother by adverse possession. Deny partition, confirm the tenancy in common, but require an accounting to determine if either the sister or brother is indebted to the other on account of the rental payment, taxes, insurance premiums, and maintenance costs. Grant partition and require, as an adjustment, an accounting to determine if either the sister or brother is indebted to the other on account of the rental payments, taxes, insurance premiums, and maintenance costs. Grant partition to the sister and brother as equal owners, but with an accounting.
Last one says without an accounting.
Oh, I'm sorry, but without an accounting. Grant partition to sister and brother as equal owners, but without an accounting. I'm having some reading errors today. That one was not as bad as the last one. I mean, probably worse for the question, but. All right. Any thoughts here? Any last choices? All right, most people are picking C, that they could grant the partition. I mean, some people pick B, so anyone who picks C, what's the argument for why they could grant the partition here?
Because if there's a dispute, at least it makes. I mean, I'm not sure if my reasoning is great, but my thought process is that if there's a dispute between two parties who both own equal shares, in a property, that would make sense to partition the land, and then for C specifically, because the brother's been doing all these extra things, he's probably gonna either get more from the sale than the sister because he's been paying all the taxes and doing the maintenance.
Oh shit, you guys can see me already writing? Yeah, I like C. I think we're gonna grant the partition. Exactly. I was just writing what you were saying. You agree, Victoria?
Mhm.
C, that's what you picked? True. C is correct. The court should grant the partition by sale for the sister, but the costs incurred and profits made by the brother require an accounting to ensure that each of them receives an equal interest as tenants in common. So if there's a dispute between two parties who own equal shares in the property, a partition may be granted and an accounting may be ordered to make sure costs are divided fairly.
Would one of the counterclaims, and this is just thinking about how this might like manifest in another question or in an essay or something, what if his counterclaims be an ouster because he's been the one providing all of the essentially the maintenance and the costs and everything, or would it just be like contribution from her?
Yeah, I mean, that like on an essay, you could argue that an ouster has occurred, but on the MBE, it's probably contribution, you know, and such. But yeah, I hear you that he does have an argument. There's been an ouster, but it seems that she's come back and she has rights and they're gonna partition the property as the best answer choice here. But I don't disagree with you that that could be a potential argument. And then I saw
I picked C, but I was curious about that like that would be what would indicate that B might be an answer because if he raised all available counterclaims and that was a counterclaim, then they would deny the partition, right?
maybe, yeah, sure. That's it. I mean, again, it's just like when Heather said in the last one, well, oh, maybe the guy was a bona fide purchaser, and so the next person took shelter. It's like, yes, maybe, but like, it's a little bit too much to draw here. Has there been an ouster? I mean, he could argue for it, but because it wasn't presented in the answer choices, like, I don't think, deny the partition and then confirm the tenancy in common, it wouldn't be B, right? And A, it wouldn't be because adverse possession, it would be like you're saying, because an ouster would be maybe a potential answer, but none of the answers here would call for that. All right, let's do a few more, Vic. Has the first game started? No, I don't care about those games. In this action, the buyer should, let's see, no conveyance or mortgage of real property should be good against subsequent purchaser for value without notice unless the same be recorded to law. So here we know that it's a pure notice jurisdiction, and we also see that it protects subsequent purchasers. It doesn't protect any, it doesn't say anything about judgment creditors. Okay, so 8 years ago, a doctor, prior to moving to a distant city, conveyed Blackacre, an isolated farm, to his son by a quitclaim deed. His son paid no consideration. The son, who was 19 years old, without formal education and without experience in business, took possession of Blackacre and operated the farm but neglected to record his deed. Subsequently, the doctor conveyed Blackacre to a buyer by warranty deed. The buyer, a substantial land and timber promoter, paid valuable consideration for the deed to him. He was unaware of the son's possession, his quitclaim deed, or his relationship to the doctor. The buyer promptly and properly recorded his deed and began removing timber from the land. Immediately upon learning of the buyer's actions, the son recorded his deed and brought an appropriate action to enjoin the buyer from removing the timber and to quiet title. The Recording Act of Jurisdiction provides, no conveyance or mortgage of real property shall be good against subsequent purchasers for value and without notice unless the same be recorded according to law. In this action, the buyer should prevail because a warranty deed for valuable consideration takes priority over a quitclaim deed without consideration. Prevail because the doctor's subsequent conveyance to the buyer revoked the gift to the son. Lose because the son's possession charged the buyer with notice, or lose because the equities favor the son. Is this the same poll or, sorry,
Mhm.
you need a new poll, yeah. Go ahead. Take care, Eric. Take care, Safila. I bet they both left. Any other thoughts?
This is a little trick inserted,
Yeah,
but
I
it's
mean,
it
took
didn't.
possession of Blackacre and operated the farm, right?
Yeah, it was obvious. The farm operation should be pretty obvious.
I mean, we have a huge split amongst the class, but
Let's see.
you think it's C to merit, right?
Mhm.
I
What do you
think
think?
it's C too. It's pretty close because I initially thought A, but the operation
I mean, A,
it's like a parent.
Yeah, he had
Um,
notice.
It's pretty obvious. Yeah, it should
yeah,
be.
and
Yeah,
A,
inquiry notice.
A is just not true. I mean, the deed's recorded. We're not really worried about the consideration. That's a contract part. Once the deed's recorded, it's recorded. A quitclaim deed that's recorded will prevail over a warranty deed if the quitclaim deed was recorded first or whatever it may be. But it's going to be C, lose because the son's possession charged the buyer with notice. It literally says the son was operating a farm, right? He took possession and operated the farm. So that's inquiry notice. A reasonable inspection of the property would have put the buyer on notice, right? So he wasn't Why does it say he's unaware of the son's possession? Because he was actually did not have actual notice, but he had what's called inquiry notice, right? Inquiry notice means that a reasonable inspection of the property. This guy's an idiot. You know, you never looked at the property and saw that someone was operating a farm on it. You were tasked with inquiring and doing a reasonable inspection of the property. Does that make sense, Alex? That's what I would get. Let's try C. Yeah. I just think it's gonna be an inquiry notice type situation. Yeah, C is correct. The recording statute identified in the facts is a notice act. In this case, the facts state that the buyer was unaware of the son's possession. The buyer, however, is charged with inquiry notice by virtue of the fact that the son's possession and use of the land were open and notorious. Further, majority of jurisdictions charge a grantee with knowledge of whatever she would discover by the inspection of the property. Under the theory, buyer's notice prevents him from being protected by the recording statute. So a buyer will be charged with inquiry notice if a reasonable inspection of the property would have provided notice of the interest. For example, if a buyer does not actually know someone is operating a farm on the property, they still are not a BFP because they will be charged with inquiry notice, since they should have known of the use / possession. I'm glad you asked that question, Alex, because that's like very narrow onto exactly what we're talking about. All right, let's just try a couple more. Like, we'll do them a little quicker. Perfect. So let's try this poll. Okay, if the man prevails in appropriate action to recover title to the property, what will be the most likely reason? Cool, I really like this question. This really hammer something home. A man owned property that he used as his residence. The man, take care of it. The man received a loan secured by a mortgage on the property from a bank. Later, the man defaulted on the loan. The bank then brought an appropriate action to foreclose the mortgage, was the sole bidder at the judicial sale, and received title to the property as a result of the foreclosure sale. Shortly after the foreclosure sale, the man received a substantial inheritance. He approached the bank to repurchase the property, but the bank had decided to build a branch office on the property and declined to sell. If the man prevails in appropriate action to recover title to the property, what will be the most likely reason? He had used the property as his residence. He timely exercised an equitable right of redemption. The court applied the doctrine of exoneration. The jurisdiction provides a statutory right of redemption. So it's after the foreclosure sale. After the foreclosure sale, is that going to be an equitable right of redemption or a statutory right of redemption?
Statutory.
Yeah, it's going to be a statutory right of redemption. So if a mortgagor can buy back a property after a foreclosure sale, this is a statutory right of redemption. The right to buy back a property before a foreclosure sale is an equitable right of redemption. So everyone got this one right. Vic, you agree it's D as in dog?
Mhm.
All right. Let's do one more. One more sounds good. And for everyone who, I know a lot of people had to cut out and we didn't get to do that many today. I mean, because I was doing some of the thinkific ones at the beginning and we were talking a little bit of football. I have done all these workshops in the past, right? Where I've done the same exact thing and it's random. And, many years ago, I used to do a 3-hour workshop when it was a different schedule. But, it's the same exact thing where you can watch the videos we do and you can follow along and you can do the questions in real time and try to answer them and then hear the explanations and go through. I think that's a really valuable exercise. So just know that we didn't do that many questions today, but you can literally watch the recordings that are in the classroom from July and from February 2024 and, you know, go over tons of questions and I put them all in a cram guide. So, you know, this is just to teach and to reinforce and hopefully, you know, we learned some really great things today. I think so far, one thing that a lot of people probably got wrong was that the overuse of an easement does not lead to termination. It just calls for injunctive relief, or a surcharge. And then for the delivery one, where there has to be actual intent for the deed to be delivered. And it has to be so that the deed cannot be reclaimed. Like if Tommy delivers a deed to Johnny, but says, if you know, don't graduate college, then I take the deed back. That's not actual delivery. It has to leave their control. So some cool things we learned today. Let's do one last question and have a happy Sunday. So which of the following concerning the security deposit is true? A teacher's moving into a new apartment building. The building has 5 floors with 3 apartments on each floor. The building also has common areas shared between the residents, including a laundry room and a rooftop deck. The teacher is moving into one of the apartments on the 5th floor and is bringing her new golden retriever puppy with her. The landlord is charging the teacher 3 months' rent as a security deposit, even though the other tenants in the building without dogs had to pay only 1 month's rent as a security deposit. What are they discriminating against dogs? The security deposit is to be placed in an escrow account with the earned interest on the account belonging to the landlord. The building is located in a jurisdiction that follows the majority approach to a landlord-tenant law. The landlord may, which of the following concerning the security deposit is true? The landlord may only charge the teacher extra for her dog while the dog is a puppy. The landlord may charge 3 months rent for security deposit. The landlord may not keep the security deposit in escrow account. The landlord may not keep the earned interest. Ooh, I like this question actually. At first I was like, what are they even getting at here? But I like this.
Andrew, can you show the poll one more time, please?
Show the poll.
Like, yeah, I accidentally X'd it out.
There should be an option at the bottom where I think it says like it's under more or something. It says or the meeting info is with the poll thing. If you accidentally exit out of the polls, possibly.
Wait, Ariana, what
Oh,
do you think?
yep, I got it.
What
I
do you
got
think-
it. Sorry.
What do you think the answer is, Ariana?
I think it's D.
All right, good. Me too. Everyone thinks it's D. Why can the landlord not keep the earned interest? Because that would make that a security. That would make it an investment account. So when a landlord retains a security deposit, they put in an escrow account. An escrow account is just like a bank that'll oversee the money so that the landlord can't take the money and go, you know, gamble on the Packers tonight and lose it all or something like that. So the money will stay in an escrow account. Now, okay, that money's going to stay in an escrow account for a whole year. Well, you know, you guys want to come to one of my Series 7, Series 66 classes and learn about stock market, they'll tell you that the dumbest place to keep your money for a year is under the mattress. Why? Because it's going to lose out to inflation. It's actually going to decrease in value. You have to earn money. You have to earn interest, whether you invest in something like a municipal bond or, you know, a CD, a certificate of deposit, just some interest bearing account is, you know, makes sense. It's like you got to fight against inflation. So if that security deposit is going to stay in an escrow account for a year, doesn't it make sense that it should be in some interest bearing account, some account that the bank will guarantee will earn like 2% interest? Sure, right? Now, who gets to keep that interest is the question. The landlord or the tenant? The tenant, right? Because it's the tenant's money. The landlord can't the landlord can't just be collecting people's security deposits and then investing it and making interest on it. That would be a crazy scenario. It's the tenant's right to keep the interest. So I agree with the class here. Vic, you agree with D?
Yep.
All right, let's run it. So the tenant, not the landlord, is entitled to interest on a security deposit escrow account. All right, cool. You know, we did a certain amount of questions. It wasn't like super voluminous, but I thought it was good. It was yeah, 12 questions is fair enough. I thought it was good to learn and to go through questions. And I mean, this exercise is amazing. So I encourage people who are in study groups to do this together. If you do tutoring sessions with me, I do this with my students a lot. Like, let's just run through questions together and talk about them. And then on your own, you know, the pad review method, do questions. And if you get them wrong, document the rule of law. And we're continuing to create this master cram guide that we have that, you know, this is the February cram guide that we've created, which you should definitely be reviewing and going over. But then I also have the master cram guide from previous administrations that I'll add this to. So it's just like, these points will lead you to success on test day. I promise you that. If you have any questions for me, I'll answer them after the recording. I'm gonna go ahead and stop this recording.